All right, we're here at the United States Supreme Court. Obviously, we like to do, we do, what do you call it? Landmarks. So you know that we're here. But, all right, we're going to serve this writ of certiorari to the United States Supreme Court. If you haven't figured it out by now, I was in the Army. I served with a bunch of wonderful people. We deployed as peacekeepers to the Balkans. My brothers would later, and sisters too, would later deploy to combat operations in Iraq and Afghanistan. Paid a really heavy toll. 2 infantry, the 1st Infantry Division. I complimented their valor by volunteering to the United States Department of Justice. I married somebody years later. During that time, I was married to somebody when I was in the Army whose family member, their father, would be taken by force by cartel associates and unalived in San Diego. And so that would be the building blocks in part for the service that I would perform later on. And that's what we're here for. We're asking the United States Supreme Court to take this under. And I did see something, some dude was talking about, he called Kash Patel on the phone, and he was talking about his rights to overpower that of the protections that put in place for witnesses, victims, confidential human sources, and otherwise. And so I'm gonna make a video to properly address that, because he's wrong, because there's special laws in place that you can't even FOIA that information. Things like 19 CFR 161.15, and there's a subsection, that goes to that prohibits even a FOIA. So what we're here to do is that video and that guy and that subject and whatever conflict he has, which I understand, if his rights were abridged, I totally get it. But his assertion that his rights overpower the protections of confidential human sources, I disagree. And that's what we're here to do, is to ask the United States Supreme Court to ensure that those protections are kept in place and honored in lower courts, like civil courts and family courts. Because in this circumstance, I was denied the ability to go in camera, and in doing so, it was a willful and intentional denial, because they were trying to protect the person on the other side, because that individual works for them, but that individual used to work for them people that are now on the list of global security threat groups, FTOs, whatever you want to call them. So that makes their conduct providing material support to FTOs, potentially under that 18 USC 2339 Bravo. I mean, if you're caught providing material support to FTOs, that's 100% a crime. But there's a case called Holder versus Humanitarian Aid, where they kind of left that open. Are state actors that may potentially abuse confidential human source protections or conduct. It doesn't have to be like where you drive to somebody's house and hand them over something they may use for it. It could be inadvertent. It doesn't have to be money. There's all kinds of ways to provide material support to FTOs, and that's what the Holder versus Humanitarian case presented. They asserted that, but they wanted to leave it open so that if another case comes along, and this case could be that case, that the Supreme Court could take up and decide whether state actors who fail to protect confidential human source protections are providing material support to FTOs. So we'll file this with the Supreme Court here and see what happens. Okay, so what we have in here is the writ of certiorari themselves. There's some other documentation. There is a request for stay, which would go to the Chief Justice in this case, because he oversees the Ninth Circuit, which California falls under that purview. There's also a request that I got to mail to the Solicitor General to humbly ask if the DOJ would be willing to utilize their investigative powers to do a certiorari. Because there is national security implications in this case, it would make sense. There is an active case here in Washington, D.C. It's John Anaya versus County of Napa et al. That's relative to all this. I'm taking these sacrifices. They push me in a corner, and there's nowhere to go but to fight outwards and to protect my son. And so this sacrifice that I'm making for the country that I love, yet again, there's the people. It's time to emulate the courage of my brothers that fell in combat, and the people that didn't fail, and the ones that came home, but the people that made a decision to honor an oath and raise their hand and defend the Constitution, to honor and compliment their valor yet again. So here I am. There's the cartel and these gangs are real dangerous people. They don't mess about. But it's important that this decision be made. So there's a case, John Anaya versus Napa County et al. In DC. There's a John Anaya versus County of Napa et al. It's a 42 USC 1983 out of the Eastern District of Virginia, Richmond. And there's a John Anaya versus the DOJ here in DC as well. But I'm not preferring action against them in a derogatory manner. It's what I've been trying to tell y'all is what I've learned about coming here to DC is coming here and hooting and hollering doesn't do a whole bunch. You actually got to go prefer action so you can get your evidence before the people that actually can do something. So let's do that. We're going to file it the writ of certiorari to the United States Supreme Court. All right, folks, so it is filed. And so there's a security protocol here for the United States Supreme Court that doesn't exist anywhere else. They do a screening for NBC, that's nuclear, biological, chemical. So the advantage to you as a litigant is that you can serve this United States Supreme Court your documents 24 hours a day, 7 days a week. And for logistics, that's advantageous to you because it can get really costly trying to come in and battle through traffic, which I'm trying to hurry up and get the heck out of here so I don't get stuck in too much because it can get nasty. So you can fly in on a weekend or later in the day, and that's going to be easier for you to access the building because mailing it in can be really expensive. You can't e-file with SCOTUS and everything. So again, we're asking the United States Supreme Court to ascertain the conduct of not only Napa County, but of the First District Court of Appeals and the Supreme Court of California, whether their conduct is providing material support to FTOs. Because as you guys have heard, each one of them were afforded the opportunity to allow me to go in camera. I found a case right now. It was here in DC, and it has to do with the CIA and the people that are involved with this. They were the litigators, as it were, here. And throughout all you'll see in-camera review. I consistently asked and pleaded with them for in-camera review, and they refused to do so. And in that circumstance, that can cost human life. I told them that. I made them well aware, yet they pressed forward. And their conduct is a clear retaliation and or covering and concealment for the lower court, which is their buddies, because the person who's on the other side of that documentation was arrested for trafficking for the cartel in 2010. And so me and the United States operated against these groups, and therefore these judges had a duty to protect the life of my son, which they neglected to do, and then it became wanton, reckless abandon. It was intentional, and you can hear it. So that's what the issue in DC is at the DC court, is to ask the United States Department of Justice to hold them accountable. Now we're asking the United States Supreme Court to make sure this doesn't happen to somebody else. This is a duty. And then we have the Eastern District of Virginia, Richmond, to ask that they be held accountable civilly. And they're doing everything they can with these attorneys and using the taxpayer money to try to use Younger abstention and Rooker Feldman. There's a myriad of defenses that they will try to utilize to cover their tracks. But can you imagine the justices here, when they read the documentation, at some point they're going to have to hear the audio to be like, hey man, this dude told you, and if this was me, I would be upset too. You guys put not only him but his family in harm's way, and this should never happen again. So people that have disgraced the robe, their honor, their duty, can now be seen by the highest court in the land, and they can potentially make sure this doesn't happen to nobody again through a review of certiorari. And again, like I said, I've asked for criminal action to be preferred against them through the proper channels in the DC court with the Honorable DOJ, and I've asked for the Honorable Court in the Eastern District of Virginia to hold them accountable civilly. Because if you prefer harm against somebody in another state, you're violating that state's jurisdiction. And what they've done in Napa is they're trying to bunker behind their sovereignty by violating the sovereignty of the Commonwealth of Virginia. It's bizarre. And they're using abstentia, Younger abstentia, Rooker Feldman, and all these other avenues. So it's a huge, huge mess. And I'm not an attorney. I'm just a regular person like you guys. But I hope some people out there are willing to fight this hard for their wonderful children that they love. My son is an extension of my brothers that passed away, so I'm fighting back not just to him, but to them. Love y'all. God bless.